following program is made possible in part by the Dayton Bar Association.
Hello and welcome to You in the Law. I am not Mike Monta. I am Matthew Arntz with the Montgomery County Public Defender's Office. The normal host of the program, Mike Monta, is away out in the field working on upcoming programs this evening. So I am the host this evening, and the topic for today's program is Ohio's sexual offender registration laws. Joining me as guests on our show today are Jim Dare, head of the Montgomery County Probation Department.
Probation.
And Judge Mary Kate Huffman, judge with the Montgomery County Public Common Pleas Court. And before we get to our discussion with the panelists, let me remind you that You in the Law is a monthly presentation produced here at the studios of the Dayton Access Television DATV on Channel 5, public access channel of the Time Warner cable network here in Dayton. This program is also cable cast on tape delay on public access channels of Time Warner through the services of the Miami Valley Cable Council. The executive producer for today's program is Judge Michael Brigner. We are streaming live at the website datv.org. This is an audience participation program. We'd like you to call in. The telephone number, if you'd like to call in and join our conversation, is 223-5311, 223-5311. So let me first ask our guests here on the panel to introduce themselves, tell us a little bit about their backgrounds and their current positions. Judge?
Evening. My name is Kate Huffman. I'm a judge on the Montgomery County Common Pleas Court. I've been there for almost 11 years. And I've been a practicing attorney for 22 years. Our jurisdiction in the Common Pleas Court is all civil matters as well as criminal matters. So we do frequently see individuals who are charged with sex offenses and who are then classified as sexually oriented offenders.
And you'd be remiss if you didn't tell us about your teaching career as well.
I also teach at the University of Dayton School of Law. I teach trial practice, interviewing, counseling, and negotiation, among many other things.
Okay, thank you. And Jim Dare.
Thank you very much. I've been with the Common Pleas Court for 28 years. I've been with the Adult Probation Department, started out as a probation officer and was promoted in 1993 to the Deputy Court Administrator. We have about 54 probation officers located in 3 areas throughout Dayton. Over on Gettysburg, at the Common Pleas Court building, and at the Rival building.
Okay, thank you. And we've selected these two guests this evening because each of them are regularly involved in the handling of sexual offender registration in the Montgomery County judicial system. We'd like to begin, I think, by talking about the sexual offender registration laws here in Ohio. Maybe it'd be helpful to give us a little bit of history. Could you do that
Sure.
for us?
I'd be happy to do so. Prior to 1994, sex offender registration was a state issue. Several states had sex offender registration requirements, but it wasn't until 1994 when the federal Congress passed a law that required each state to comply with certain minimum standards for sex offender registration. The law was known as the Jacob Wetterling Act, and it required states, as I said, to have sex offender registration laws or risk losing millions of dollars in federal crime funds. And so there was a significant impetus for states to pass sex offender registration laws. there's been a series of different sex offender registration laws since 1994, all of which have been spurred by very heinous crimes involving children. The Jacob Wordeling Act, the Megan's Law, and then the Adam Walsh Act, all grew out of concern for crimes against children that were of a sexual nature.
Yeah, I think we all recall some of those notorious cases that got a lot of publicity and caused the national legislature to begin the process of requiring registration of sex offenders. So it began sort of at the federal level and then moved on down to the states.
Sure. The states are required to pass legislation that would enact, now the Adam Walsh Act, that's the most recent in 2006, or risk losing that significant federal funding. And so there's really no choice for states but to comply with that federal legislation.
And my understanding is that as of this time, all of the 50 states have done so. Is that correct?
That's
They've
my
all
understanding.
enacted one form or another of sexual offender registration laws.
Currently, they're required to implement the Adam Walsh Act, which went into effect nationally in 2006, but because crimes are of a state nature, then the states were required to implement the Adam Walsh Act in order to give effect to the national legislation.
Okay, and do I understand also that this federal legislation required the states to have certain common components
Certainly.
in their sexual registration laws?
Starting in '94, the requirements were rather vague. There were requirements to have registration, there was requirements to have a centralized database, and as we've gone through this progression of laws up to the current legislation, which is the Adam Walsh Act, things have changed with each set of legislation to the point that now the national legislation through the Adam Walsh Act, as implemented by the states, requires that offenders be designated in one of three different tiers: Tier 1, Tier 2, or Tier 3 sex offenders, with Tier 3 being the most serious offenses. The Act requires that the registration requirements be uniform. That is, for instance, the Tier 1 offenders in each state must have the same registration requirements. Tier 2 and Tier 3 must have the same requirements. It's how the states then implement them. One of the most significant requirements from the Adam Walsh Act is there's a requirement for a national database of all registered sex offenders that is implemented through databases that are prepared by state attorney generals.
Okay.
So in Ohio, the attorney general has implemented the requirement for the database, and that feeds into the national database.
Well, let me break that out a little bit. When we talk about tiers, we're talking about classifying sexual offenders in some form. Is that correct?
That's correct. They're classified by the type of offense that they were found guilty of or pled guilty to.
All right, so depending upon what kind of offense they committed, we will classify them in one of three categories. Is that correct?
That's correct.
Okay. And Judge, you indicated that, at least here in Ohio, we call them tiers 1, 2, or 3.
Correct.
With 3 being those who've committed the most serious sexual offenses, and 1, those persons who've committed the least serious sexual offenses.
Correct.
And then depending on what category you've been designated, you have certain reporting requirements for a certain period of time.
Correct. Prior to 2006, when the Adam Walsh Act became the national standard that each state had to implement, judges had discretion, and judges could choose to designate offenders as a sexually oriented offender, a habitual offender, and now it's been so long I forget what the third
Predator.
category. Thank you.
Sexual predator.
Sexual predator. Thank you. And there was a great deal of judicial discretion, and the judge would hold a hearing, hear evidence. There was an instrument that was used to assist the judge in determining the risk of future offenses and the risk of the offender. With the Adam Walsh Act, all of that judicial discretion was removed, and it is automatic. And so if you are convicted of a particular offense, the judge has absolutely no discretion in designating you as either a Tier 1, a Tier 2, or a Tier 3 sex offender.
So prior to this recent legislation, a judge could say, regardless of what offense you had committed, I would like to make my own independent determination as to your future dangerousness, how much supervision you require, that kind of thing, before labeling you.
Correct. The judge was still required to designate you as a sexually oriented offender, but it was what classification you received. The judge had discretion, again, based on the evidence, and then you would still be required to register. It was what your registration requirements were. In addition, there were community notification opportunities, and the judge would determine if there would be community notification. And community notification involves, for lack of a really better term, neighbors of the offender being notified of where the offender lives and their registration status. That is only required under the Adam Walsh Act of Tier 3 offenders. Under prior legislation, there was a bit more opportunity for the judge to require a community notification.
So what we're saying is, over the number of years and this series of legislation, the requirements for sexual offender registration have become more automatic, or more...
they're more automatic, and they're more onerous.
More onerous.
The original legislation was 10 years. And then I believe the second category was 15
10,
years?
15,
10, 15,
and life.
And then lifetime. Now the categories are 15, 25, and life.
So we're
it's
now
a
requiring
minimum,
longer periods of registration.
correct, a minimum period of registration of 15 years.
Okay. And again, the more serious the offense committed, the longer the period of registration that's required.
Correct. Offenses like rape, kidnapping with a sexual motivation, anything that's a very serious or a very violent sexual offense will typically carry the lifetime registration requirements. And they're required to register every 90 days for their lifetime. So every 90 days they would go to the sheriff's department and verify the information, that is their home address, school, place of employment, place where they're attaining higher education, internet identifiers, phone numbers, that type of information, every 90 days.
And to be clear about that, I guess the sexual offenders are required to do this registration at the office of the sheriff in the county in which they reside. Is that correct?
Correct.
Okay. So it becomes a question of where you live, and based on where you live, you're going to go to that sheriff's office, and you're going to provide an awful lot of personal information about yourself, it sounds like.
And you're required to, if you move, if you go on vacation, if you leave the state for any purpose, not only are you required to notify the sheriff of the county in which you live, but the sheriff of the county in which you are going. So if you're going to Indiana for the weekend, you must not only notify the sheriff here, but you must notify the sheriff of the county in Indiana where you'll be for the weekend.
Okay, so if I move from Dayton, Ohio to Muncie, Indiana, I have to let the sheriff in Montgomery County know I'm moving to Muncie, Indiana.
As well as the sheriff in Muncie, Indiana, because the Indiana authorities are required to implement the registration requirements in Ohio. So wherever those registration requirements follow you.
Right.
And so an offender can't leave the state of Ohio and leave their registration requirements behind.
Right.
They follow you anywhere in the country.
Wherever you go.
Absolutely.
Okay. And why don't we talk a little bit about why we think we have such laws? I mean, what is the rationale or the logic or the reasoning behind tracking sex offenders in this fashion? What was involved in that, do we think?
Well, originally, I think, again, it was some high-profile cases, and then basically they're wanting you to monitor these offenders for a long period of time. And I think they would probably say it's for public safety. And that's where we have to come in and try to carry out that particular plan to make sure that that's happening.
So there may have been some research, or at least some conclusion that folks who commit sexual offenses are inclined or predisposed to offend again.
Well,
Is
the
that
research
correct?
doesn't bear that out.
All right.
The research does not bear out that an individual who commits a sex offense is at any greater risk to commit an additional offense than any other offender. In fact, the recidivism rates for sex offenders are quite low.
Okay, so what we're saying now is the research and study that's been done doesn't indicate that sex offenders are more likely to commit future sex offenses than, say, burglars are likely to commit burglary, or...
In fact, the sex offenders have a much lower recidivism rate than all other offenders.
That's interesting. Nevertheless, we're going to track the sex offender for, I think we said 10 or 25 or entire
15.
life.
15, 25, or life.
15, 25, or life. And this is regardless of the offender's age
Correct.
or...
Juveniles are treated differently. There are special rules for juveniles. There are opt-out provisions for the juvenile judge to choose not to require registration. But those rules are much different than for adults. There is no discretion when it comes to adults.
Okay. And I hear you saying a couple of times no discretion. So a judge, let's kind of flesh that out. A judge doesn't necessarily have much leeway or flexibility or
There's no leeway.
independent
None
judgment to make.
None whatsoever when it comes to requiring sex offender registration. If an individual pleads guilty to or is convicted of any sexually oriented offense, no judge has discretion. They absolutely must categorize and require sex offender registration, compliance with all of the requirements, without the judge using any of the things that we use, for instance, in sentencing. Sentencing is an individualized affair, and that is, you look at the individual defendant, their life history, perhaps their substance abuse history, their criminal history, their educational history, their potential for future dangerousness, lots of different factors in crafting an individual sentence for each defendant. Sex offender registration requirements ignore the individual and require that each offender be placed into a very neat category based upon the type of offense.
Okay. So ordinarily, if I pled guilty to a felony in your court, I haven't had that happen yet, but
I don't think that'll happen.
you would want to find out all about me before you decide what a sentence was appropriate for me. And what would you do to find out about me?
We have a department, our pretrial services department does an investigation, and that investigation will include the nature of the offense, so the facts of the case, a statement from the victim, and if the victim is a minor, their parents or family members, a detailed history of your criminal history, your education, your work history, any mental health or substance abuse history, any gang involvement. So your family or social history, are you married, do you have children, do you have any support mechanism that could assist you in rehabilitation? So lots of different information that is gathered into what's called a pre-sentence investigation, and then that, along with the defendant's statement, his lawyer's statement, and any victim statement, are considered by the court in sentencing.
Okay. So in most cases, you have the opportunity to try to fashion a sentence which is appropriate to that individual. But I hear you saying that in a sex case, the laws tell you what you're going to do.
The law doesn't necessarily tell you what you're going to do with the sentence. It might, because there are many sex offenses for which a prison sentence is mandatory.
Right.
But when it comes to that portion of the sentencing procedure that involves sex offender registration, the judge has no discretion whatsoever.
Just a reminder, this is an audience participation program. We invite your telephone calls with questions and comments. You can tell whether we're coming to you live or by replay by watching for the telephone number at the bottom of your screen. If you're watching us this evening, you can call us right now at 223-5311, 223-5311 to put you in contact with our panel. And Judge, if a sex offender came before you, was eligible for probation, and you determined that that person was an appropriate candidate for probation, you put that person on probation, he would be put in contact with a probation officer in Jim Dare's office. Is that correct?
Absolutely. From the time of sentencing, that individual becomes Jim Dare's charge, and his department. They will certainly monitor, and Jim can speak more about those issues in terms of what types of treatment and opportunities are available.
Once the person is sentenced to community control or probation, which is usually the tier 1s, there's a number of things that they have to follow. The judge has ordered that they follow all general conditions, and there are 11 of those. And those are basically don't violate the law, make sure that you report. Those are some of the just general categories for all people placed under our supervision. Second is there are 17 special conditions for sex offenders.
What are some of those?
Some of them, and again, I'm going to have to refer to the document which they have to sign. The most important is they have to complete treatment. And most of the offenders are in treatment for about 2.5 years. Some are longer, some may be a little shorter, but the average amount of time is 2.5 years. We have 2 local treatment providers, and then we have 2 agencies. One is in Cincinnati, and the other one is the Volunteers of America that also assist us with this population.
And can we say something about what we mean by treatment?
Well, they're trying to make the individual take responsibility for their behavior, what drove them to make those decisions, and try to develop a relapse plan, again, to prevent them from doing that again.
So this is intensive counseling in a sense.
Absolutely. There's individual counseling, group counseling, and it's monitored very closely by the 2 probation officers. If they don't have a reason for attending a group or an individual session, they don't have a good reason for missing it, there are consequences for that behavior.
That was my next question. You get
Which
reports,
could be up to arrest.
Right, you get reports back if someone doesn't follow through with the treatment, is that
Absolutely. The treatment provider always keeps us posted, keeps the 2 probation officers posted on their offenders, on their casebook, so that we know they are attending, that they're not just attending, they have to participate in the treatment. They
Right.
can't just go there and sit and not do anything, not complete their homework assignments, and not be serious about getting this issue addressed.
So let's tell people what happens if they don't attend any of these classes.
If they don't attend the sessions, again, there's some progressive sanctions that could take place. You know, they could get a warning from the probation officer. We call putting them in jail therapeutic incarceration. Again, trying to get their attention, as opposed to saying, let's take them back in front of the court and file a formal revocation and recommend that they go to prison. We're trying to get their attention at a lower level in the progressive sanctions, but it's very limited with this population. We're very serious about them being in compliant with the court orders.
Sure.
And if they're not, then again, like I say, there's consequences.
So am I correct that every sexual offender would be required to participate in some form of treatment,
Yes,
regardless of the offense that was committed?
correct.
Okay. What other kinds of special conditions are there?
With that population, some of them also have drug and alcohol issues, so we're monitoring that as well as the sex offender issues and also some maybe possible mental health issues. We drug test the sex offenders weekly when they report. We either do a urinalysis test or we have ocular testing equipment where the individual would sit in front of a machine and kind of look through these little goggles, and it reads the capillaries on the back of your optic nerve to see if they're using some type of drug, and or they also do a breathalyzer test with that machine too. So,
Wow.
we also work closely with the sheriff's office to make sure they're registering. That's one of their responsibilities, but we try to reinforce it so that they don't miss the deadlines if they have to report every 90 days to register or every 180 days or on an annual basis.
So you're sort of monitoring that and trying to encourage them to stay current with the schedule of registration at the sheriff's office?
Absolutely.
And if they don't register with the sheriff's office, do you hear back from the sheriff?
The sheriff will call us, and sometimes the sheriff will contact the prosecutor's office for additional charges of failure to register.
So if I'm a sex offender required to register with the sheriff, I don't bother to do that, the sheriff can call the prosecutor and I can actually pick up new criminal charges for failing to register.
Correct.
And are those felony charges or misdemeanor charges?
Those are felony charges.
A failure to register or a failure to notify if you change your address or any information is always a felony. And it can be very serious. There are failure to notify or failure to register offenses for which it's a mandatory prison sentence.
So if I register false information with the sheriff,
False, or you fail to register, or if you don't register on time, you can be a day late and you have committed a new criminal offense, and it will be a felony.
all right? And you just said that that failure can cause automatic incarceration.
There are different circumstances under which it's automatic incarceration. The first is depending on the level of your first felony. If you've been convicted of any felony of the first or second degree, and you commit a second felony of the first or second degree, it's mandatory prison in Ohio no matter what the offense, whether it's a sex offense or otherwise. Failure to notify offenses, depending on your original offense, can often be a felony of the first and second degree, which is a mandatory prison sentence. In addition, if you fail to register twice, so if you've been convicted of a failure to register and then you've been convicted a second time, it's a mandatory minimum of 3 years in prison.
Okay. And how is it that I'm notified about all these requirements, these registration requirements that I have?
At your sentencing, the judge is required to read to you, and you've been present when that's happened
Yes,
before.
I
It's
have.
a long document. The judge not only reads it to the defendant receives a copy at the time of their sentencing, and then the sheriff, with each time the defendant registers or verifies their information with the sheriff will provide them with another document that repeats the same requirement. The requirements don't ever change, but the offenders are repeatedly notified.
Okay, and this is reinforced over and over again, apparently.
Absolutely, including through their probation officer. If they're on parole, if they've gone to the institution and been released, the same information would be reinforced by their parole officer.
So they're hearing it from several different sources, it sounds like.
Absolutely.
Okay. What other kinds of things does the probation department do with
We want
sex offender clients?
We want to make sure that they're paying restitution to the victim if the victim required any type of counseling or needed any type of assistance.
Medical expenses?
Absolutely. And we also have no contact with the victim. We make sure that that takes place and check on that. Avoid places where children congregate. They're told that they can't do that. They're not able to own, operate, or have a business that is predominantly providing services for people under the age of 18. They're to have no sexual contact, date, or socialize with anyone under the age of 18. They're not to utilize any sexually oriented 800, 900 numbers. They're not to be viewing or downloading sexually oriented material on their computer. And they're not to enter any establishment whose primary purpose is for sexually oriented business. They have to observe curfews. We sometimes require some of them to maintain a driving log so that we know where they are, when they're going different places. And again, we also ensure that they don't live within 1,000 feet of a school, a preschool, or a child daycare.
So the law actually tells them something about where they're permitted to live after they've been convicted of one of these crimes.
Correct. And sometimes that's difficult. If they were living with their parents and their parents live in, closer than 1,000 feet to one of the places I just named, they're not allowed to live with their parents and have to look for housing somewhere else. And that's where sometimes we have to put them in housing that's provided by the state or some type of halfway house.
Temporary housing. Okay. Do I understand you also make home visits to these folks?
Yes, the probation officers go out in teams of 2, and then they'll go into the home and they'll look around and make sure there's no contraband, none of the materials, you know, that I just mentioned. They have had, sometimes they'll look on their computer to see if they've been downloading any inappropriate websites. We have taken those computers down to the courthouse, and again, they could be facing violations for having contraband in their home.
Could be a new offense, depending on what they're doing with their
Correct.
computer. Okay. And can you give us a sense of, well, one more question like that. How long are these folks supervised by you?
The majority of the time they're on supervision for the entire 5 years. The judge will order them on community control or probation for up to 5 years. And most sex offenders usually do the entire 5 years under our supervision. If they went to prison and come out on post-release control or parole, again, they'll be on supervision to post-release control or parole for a significant period of time.
And what can you tell us about the compliance rate you've observed on the part of these clients of the probation department?
The majority of them comply with all the conditions ordered by the court. Like I said, if they start to slip, then there are consequences, immediate consequences that address that. If they continue to violate the court orders, then we'll file for a formal revocation. Again, the probation officers do have the authority to arrest them. We put them in the Montgomery County Jail. If any of those clients stop reporting, we'll issue a warrant for their arrest immediately. It'll be signed by the judge. And the U.S. Marshals are very helpful in tracking those individuals down.
Okay.
So we work very closely with them. Also, they have some funds available if the person leaves the state of Ohio without permission. They can get those individuals and arrest them and bring them back to the Montgomery County Jail at no cost.
Locate them and bring them back. And Judge, I imagine you've had a number of folks appear before you who have failed to meet these conditions of probation, failed to register, left the vicinity, and
Not that many.
not many.
Yeah, I think I was just thinking when Jim was talking about the individuals who are on probation for sex offenses, there are many sex offenses, particularly those involving children, that require prison. So the judge is required to order a prison sentence. And sometimes a very lengthy prison sentence. If it's, generally speaking, if it's an offense involving a young child, it's a life sentence. Now, life in Ohio for a sex offense is 15 years or more. But nonetheless, often the judge has little discretion in the sentence. There's a mandatory sentence. So the individuals who are on probation have committed low-level sex offenses, typically not involving children and typically not involving any violence.
Right.
Those are the individuals who are of much more concern. I do want to add, though, to what Jim mentioned, and that is that his department supervises sex offenders very closely.
Apparently.
They report weekly, which is unusual. Not unusual. It's often not what other offenders, perhaps someone who commits a theft offense or something like that, they'll report much less frequently. But the sex offenders are on an intensive level of supervision and very, very closely monitored. So it's not very often that we'll see someone placed on probation that comes back for either a new offense or a violation of probation. If they do, the ones that I have seen have typically involved, and Jim mentioned it, they'll find some pornography on their computer, or they're not in compliance with treatment. But generally speaking, I've not seen individuals commit new offenses, with the exception of offenses that may relate to their inability to become employed or the other social stigma that goes along with being a registered sex offender. Registered sex offenders often have difficulty finding employment or keeping employment, and they are socially stigmatized. You know, when you can look on a website and find that your neighbor is a registered sex offender, that will more than likely not cause you to develop a friendship or a social relationship with them. So the research is very clear that sex offenders, if they're committing new offenses, they're often other non-sex related offenses, theft offenses, drug offenses, because the more marginalized that offender becomes, the more they may gravitate to individuals who are also marginalized, that is, other individuals who have committed criminal offenses, not necessarily sex offenses. So their social circle and their support mechanism is very strained. Often very strained relationships with family, social relationships, children, spouses, obviously. Difficult to establish a healthy adult relationship because of their registration requirements. If you're a 35-year-old woman and you're looking to date and you meet an individual who's a 35-year-old registered sex offender, you're not going to be willing to have a relationship with that individual and have them around your children, no matter what their offense was. And so it's difficult to establish new healthy relationships. And so the individuals are often, as I said, more marginalized, which compromises their ability to be successful.
So these consequences follow them in not only in the legal system, but in their entire lives.
Professionally, absolutely.
I just need to remind you that you are tuned into You and the Law. We are a monthly program produced at the studios of Dayton Access Television. We're cablecast locally on the local public access channels of Viacom, Cablevision, and Continental Cablevision. We are a audience participation show. You're able to call in to us and join the discussion here at 223-5311. If you'd like to ask a question of our panel or make comments. We were just talking about the registration itself, and my understanding is that the public actually has access to some of this registration information. Is that correct?
That's correct. The public can go to the sheriff's website and look at his database, and it provides a number of different things. Again, like I said, it provides the photograph of the offender, their address, where they're working, where they're going to school, demographic information, what crime they committed. You can also generate a report for yourself, like how many sex offenders live within a 1 mile radius of my home. So people can check a lot of different things. Again, it's supposed to be from the aspect of making decisions in your community, public safety, but a lot of times, again, the individual can be, people get real angry when they find out that a sex offender is living in their neighborhood. And I think my understanding, the last time I heard, there's sex offenders in 80% of the neighborhoods.
Every neighborhood.
In Montgomery County, so they're there.
Well, didn't we used to send out postcards to notify neighbors when a sex offender lived nearby?
If you're subject to community notification, and under the Adam Walsh Act, there's a lot less discretion for the judge. Community notification is required for Tier 3 sex offenders. Anyone living within 1,000 feet of the offender is given notification. So in addition to it being available on the internet, those individuals are given direct notification by the sheriff, and they'll send a postcard indicating the address of the offender, as Jim said, the address, the nature of the offense, the name of the offender, all under the intention of public safety.
Okay. And we hear from time to time cases or incidents where a community or a neighborhood gets kind of up in arms about a particular individual who they discover is living nearby as a result of checking a website or other kinds of publicity. And the sex offender, person who's been convicted of an offense, actually has to leave where they live. Is that correct? Have we seen that kind of thing?
We've seen it because offenders are not permitted to live within 1,000 feet of a school, a daycare, or a child care, certain registered child care facilities. or preschools also. And those individuals can be either compelled to move because they're too close to such a facility, or just because of the community ostracization, they feel compelled to leave or to move. Now, there have been cases where an individual who owned a home prior to the time they were required to register as a sex offender were not required to move because they owned that home.
Right.
And in our Constitution provides that we cannot be deprived of our property without due process. So there's some debate as to whether individuals who own a home within 1,000 feet of a school or daycare center or child care center can be required to move.
We're still litigating some of these issues, even though the
absolutely.
law's been on the books for a few years. We've talked sort of generically about sex offenses, but actually in Ohio law there's a wide range of types of sex offenses, isn't there?
Absolutely.
From the most serious to the least serious. The most serious probably being rape or committing homicide or kidnapping with a sexual motivation. And some of the lesser offenses would be misdemeanor sex offenses.
There are misdemeanors that require you to register as a sex offender, all the way up through, as you said, rape or murder with a sexual motivation that are obviously much more serious. But for instance, voyeurism is a misdemeanor, typically a misdemeanor, and that requires that you register as a sex offender for 15 years.
Okay, and just in case anyone doesn't know, voyeurism is what we used to call peeping toms, or
Sure.
just peeking at someone, looking at someone surreptitiously.
Absolutely. As long as there's a sexual motivation.
Right.
But for instance, if you have an 18-year-old son who happens to decide he might want to see what the girl next door is doing, and he's charged with voyeurism, that is a registrable sex offense. The judge would be required to order registration for a period of 15 years.
Okay. 15 years for voyeurism.
Correct.
Is that right?
And it's a
Reporting.
misdemeanor offense. Certain violations of protection orders where there's any sexual motivation, which it would be a misdemeanor offense, require sex offender registration. There are certain sexual imposition offenses that are misdemeanors that again require, the individual can't go to prison, can only go to the county jail for up to 6 months, yet they can be required to register as a sex offender for 15 years.
So despite the fact that the misdemeanor jail sentence is relatively low, the misdemeanor registration requirement could go on for many years.
For up to 15 years.
And you used a term there, you talked about sexual imposition. That's an offense which involves inappropriate touching,
Correct.
basically. Is that right?
Absolutely.
Okay, and that's one of those.
There are different degrees of sexual imposition.
Sure.
There's sexual imposition, there's gross sexual imposition, there's gross sexual imposition involving a child, much different. Gross sexual imposition could involve an adult,
Right.
but under inappropriate circumstances. So it really depends on the age of the victim.
Right.
Or the condition of the victim. If the victim is disabled or
Impaired.
intoxicated, or otherwise impaired.
Okay. So, Jim, do you have, I suppose your clients include folks who've been convicted of a variety of these kinds of offenses, is that right?
Correct.
So you've had folks convicted of gross sexual imposition, unlawful sexual conduct, a variety of these felony sex offenses. And your experience to date is that the compliance rate is pretty good so far.
Correct. They follow all the court orders, they report. The judge was talking about intensive supervision. Some of them we know have to come to 3 different appointments per week. They have to report to the court, to the probation officer, they have to report to the treatment provider, and if they have a drug or alcohol problem, they have to report to that particular treatment provider. And we get information every week on all those. So and then we're doing home visits. So,
Right.
and sometimes we're going out and making sure they're actually working where they say that they're employed. So, because we want to see where they're working, who are the customers, you know, where are they working at and what's around that particular business. So,
Well, and let's talk about employment a minute. If a fellow comes to me and applies for a job with my business, and I have a practice of checking publicly available information, and I look at the sex offender registration list and his name appears on it, I understand that I can also see the name of the offense he was convicted of. Is that correct?
Correct.
correct.
But I don't necessarily know what that offense means, do I? In other words, if the registration says this fellow's been convicted of sexual imposition, if I'm a layman, I'm not sure what that means exactly.
My experience, though, is once an employer or a prospective employer learns that an individual is a registered sex offender, they're not interested in hiring. And again, this is my experience, is that most of our sex offenders who are on probation work for a family member, a friend, or they had their employment and were a trusted employee before the offense. Obtaining new employment is a challenge. In
Sure.
addition, there are many professional licenses that prohibit you from obtaining or retaining your license if you're a registered sex offender.
So if I'm a licensed professional and I commit a certain kind of a sexual offense and I'm convicted, that may have consequences for my ability to continue in my profession.
Absolutely. I think you would see that primarily with individuals who are in a profession of trust, a physician, a nurse, a teacher, daycare provider, and certainly one of the issues that always is of concern, particularly when the prosecutor's office is discussing a potential plea, is any professional license. And as you've seen in many cases, a demand or a request that individual forfeit their professional license. That forfeiture may come anyway.
Right. So in discussing how to resolve a case, sometimes we will discuss the licensure of the person and maybe the idea that they should relinquish or give up their license, at least for the present.
It will often come later anyway with the licensing authority terminating or suspending or revoking the license. That tends to be a foregone conclusion. And I don't know if Jim's experience is the same, but as I said, mine is that the offender, unless they have a family member or a close friend or have already been a trusted employee, they're going to be very challenged in their employment opportunities in the future.
Sure.
Like the judge will order us to notify the licensing board because it really is up to them whether to terminate or revoke the license. But we have an obligation to let them know.
So actually your office would be the office to make contact with the American Medical Association or whichever.
Sometimes they'll call us to get some additional information. A lot of times they'll have a hearing, you know, on the person's license. And then employers sometimes call us.
Really?
Because they want additional explanation of what this is. Because the offender will give their probation officer's name and telephone number to be contacted.
In hopes of clearing this up. And
Correct.
So you're actually able to fill this out and explain a little better to the employer.
Sometimes it works and sometimes it doesn't. So.
Sure. And just so we know, what kind of an age range are your clients there at your office?
We have as young as 18, and the oldest one right now is 76.
Wow. And how many probation officers are working there?
Well, we have 2 probation officers that deal with sex offenders, but we have a total of 54 probation officers.
Okay.
That cover all different types of offenses.
You know how many clients you have?
We have 3,120.
At present?
Correct.
In Montgomery County?
Correct.
31.
Not all sex offenders.
Right.
So
3,100 or so.
correct. On a
Persons on
daily
probation.
basis. Yes.
Okay, very interesting. Do you ever hear from the public, Judge, about this issue? You ever get any feedback?
About registration requirements?
Or about sexual offender sentencing, that kind of thing?
I would say that Any public reaction that I do hear is on the side of more serious penalties, more serious punishment. The public, though, may not be familiar with the judge's obligation when it comes to sentencing, which is to craft an individualized sentence that is consistent with the statutory purposes and principles of sentencing, which include the potential for rehabilitation, the potential need for incarceration or incapacitation to keep someone away from the public. So there are, retribution isn't really a purpose of sentencing. It may be a public purpose of sentencing, but a legal purpose, the goal is to protect the public and do what is necessary to meet the individual needs of the defendant if it's consistent with public safety.
And you referred to this earlier, but often at the time of sentencing in a sex offense case, you will actually have a statement presented to you directly by the victim.
Sometimes it's from the victim themselves, sometimes it's a representative from the prosecutor's office. That depends on, from my perspective, the comfort level of the victim. Do they want to be in the presence of their offender? Do they feel safe? It's very intimidating to talk about being the victim of a sex offense in public, in a courtroom full of people, potentially in front of the media. So that depends. I will say I once had a 16-year-old victim. Her stepfather was the offender. It was she'd been a victim for a long time, since she was a young child. And she gave a very impactful statement in a very crowded courtroom with the media present, and it took a lot of courage. And it was part of her healing, though, and she made that clear to him, that making a statement to him publicly was very cathartic for her and was part of what she needed to do for herself to heal.
Well, that's part of the reason we came up with these victim impact statements, isn't it?
A secondary reason, obviously, is also to allow the court to consider the victim's, the effect on the victim in sentencing. That's but one factor of many in terms of sentencing.
You are watching You and the Law. This is brought to you in part by the Dayton Bar Association. The Dayton Bar Association is a local agency that provides a variety of community services. It has a lawyer referral service if you're looking for a lawyer. It provides a notary public service. It can refer you out to have a will created. It has a website and a volunteer lawyers project, folks who can do certain kind of legal services for you for free. So the Dayton Bar Association at 222-6102 can help you out in a variety of ways. And I've had as my guests here Jim Dare, who is the head of the local Montgomery County Probation Department, and Judge Mary Kate Huffman, who is a judge with the Montgomery County Common Pleas Court. We've been talking about sexual offender registration laws in some detail. They're kind of complicated, but we tried to make this understandable and clear to you as best we can. I think I'd like to change the subject here at the end and ask you a different kind of a question. I think folks would find this interesting. What would you say each of you is a part of your job or your career that you find personally fulfilling, something that you really enjoy about your job, something that you think is makes it worthwhile for you to continue in your career? What is it that gets you out of bed in the morning?
I'll let you go first, Jim. He didn't tell us he was going to ask this.
That's a surprise.
It is.
I don't know if it's like what drives me, but when you see an individual do really well and change the way they think and change their behavior, and they come back, I'm not saying just during the time that they're on supervision, but if they come back later and their life seems to be somewhat in order and you're kind of proud of what interactions your department or your staff had with that individual, probably is what drives me, because people can change.
You've seen that.
Absolutely.
So it's the success stories that
Yeah, the
keep you
success
going.
stories, and we don't talk about them enough. We always want to talk about the ones that fail, which are the few who get the most attention, but the majority of them do what they need to do to meet the court orders and to I don't just want them to meet the court orders.
Right.
I want them to do positive things for themselves. And again, that's probably what drives me and drives most of the employees of the probation department.
That's interesting. And Judge, what would you say is...
Well, I would agree with Jim. I think sometimes the public doesn't necessarily understand a judge's role in that. While I feel compassion for the people that have cases in court, feel empathy and sympathy for them, the judge's role is to follow the law. And you have to set aside emotion and, as I said, sympathy and empathy, and decide the case purely based on the law. But when someone is convicted of a criminal offense, they're placed on probation, and you can help them find the tools to become a productive citizen, that is very uplifting.
Rewarding.
And yes, it's very rewarding, and
Well, I've seen you show some tough love to some clients and take a hands-on approach and really help some folks out over time. And I've seen that happen myself. So this has been a production of You in the Law, a monthly program designed to bring Montgomery County citizens news of the legal world around them. The executive producer of the series is Judge Michael Brigner. Show's produced at Dayton Access Television, cablecast on DATV, Channel 20. I want to thank the volunteers who've helped us out and also my panelists, Judge Mary Kate Huffman and Jim Dare. I am not the producer and host Mike Monta. I'm Matthew Arntz. He'll be back next month. And we thank you for joining us. Hope you enjoyed our discussion of this topic. Good night.